All right. I'm here, finally. Ugh. It's already a late night stream, at least by usual standards. For some reason, I'm a night owl. I, I realize not everyone is, and I'm in the mountain time zone, so I try to do it at a real time for those on the East Coast, which is 4 o'clock here, 6 o'clock there. But I just wasn't up to it this afternoon. So I figured, hey, the West Coast can have a prime time slot for once. Unfortunately, as I put in the chat from my phone, the computer didn't want to cooperate. It is now, so I'm here. So thanks for waiting, and hello. Good to see you. Imuji and Brandon and Debbie, and I think that's everyone that said hello so far, but yes. And Debbie, I don't think I commented on your post, but I saw them. And sometimes the trials they take precedent, they for lawyers trials take precedent, for viewers trials take precedent. So I understand it. Oops. Lee, good to see you. Caddy, good to see you too. And that's basically what I thought, Lee, is, when I start at 4 here, yeah, it's after work for those on the East Coast, and, midnight-ish for 11 midnight for those in England. But it's still the middle of the workday. It's 3 o'clock on the West Coast, and it's what, noon in Hawaii? So, you guys generally end up on the replay. The East Coast can do the replay this time, unless they're night owls like I am, then whatever, it's fine. But yeah, so that's basically what I figured, even though, like I said, I do try to be accommodating, and I realize, there's what, 200 million people in the East and Central time zones, and 70 million out this way, so it's a bit of a give and take. But Dubai, that's impressive. Well, I mean, being up at 8 a.m. on a Saturday to me is impressive. But Linux guy, good to see you. Jim Bob, good to see you. So that all being said, let's dive into it, because I have a feeling that this is hopefully not going to be quite as long as last time, but it could be, because it's me, and I'm easily distracted. As some of you saw yesterday, I literally had to stop and film a squirrel because, well, he was chonky. And Linux guy, yes, I did see that Delete Laws got a discovery sanction. He has to pay some of Blue Bacon's attorney's fees, because Delete Laws, even though he's the one that brings the litigation, but he doesn't think he is subject to discovery, and he found out that he is. And Utah is mountain time zone. The entire state is. Nevada, I think, is entirely Pacific. Idaho is weird in that it's mostly mountain, except like the upper panhandle is Pacific, because it's more Pacific Northwest than, it's weird. And I did figure, Debbie, that you thought this squirrel was cute. So yeah, but yeah. So like I said, hopefully it won't be quite as long. and hopefully my voice will last. Everyone in my house has been sick all week, or at least a little bit sick. It's those, damn kids, my niece and nephews. They're, none of them live here, but for some reason, they come over. They're like, but we live next door, but we're family, but we like getting you guys sick. And so yeah, hopefully it's we get over it soon, and all of us get over it. But yeah, so like I said, we are back in Illinois, which is Central Time Zone, for those of you who were wondering. And we are back in Braun versus Day. And last video, we looked at the SLAPP motion and motion to dismiss by Caffinated Kitti. And it was extra long. Now, today we are going, well, I've got the docket open here. So let's scroll down the docket. Like I said, last week we did 21 and 22, which were Caffinated Kitti's motion and memorandum in support. Like I've said, I don't like that this is a jurisdiction that splits them into two different docket entries. Just do it as one docket, one document. It doesn't make anything easier. It just makes it more cumbersome. But so that's what we did last week. It was extra long, but that's because Kitti has extra stuff. That there's a lot more causes of action against her. So today we have 23 and 24, which is the motion to dismiss for Bekah Day. You'll notice it's only a motion to dismiss. Now, I haven't read any of these two, but it's only a motion to dismiss because you'll remember from last week, they're asserting that for Caffinated Kitti, the Georgia anti-SLAPP law controls for Kitti because as a Georgia citizen, Georgia says she has the right to speak. And so even though this is brought in Illinois, it's Georgia law that controls for Kitti. Bekah Day lives in Missouri, which Missouri sucks in a lot of ways. And one of them is it doesn't have an anti-SLAPP law at all. And it wouldn't make sense for them to try to argue the Illinois anti-SLAPP law because then the plaintiffs, that then Janet and Lauren the Mortician would argue, hey, hang on, if the Illinois anti-SLAPP law, which is, it exists, so it's by default better than Missouri's anti-SLAPP law, but it's a lot worse than Georgia or California. So if they argued, well, just for Bekah Day, let's use the Illinois SLAPP law, then Janet's going to argue, well, in that case, the Illinois anti-SLAPP law should apply to everyone else. So for Bekah Day, they've just got to go with the motion to dismiss, 12b6, no anti-SLAPP. But then we have 25 and 26, which is the Do We Know Them girlies, Lily Marston and Jessie Vasquez. And they have the special motion to strike, the anti-SLAPP motion, and in the alternative, the motion to dismiss. And so I realized before we get into the motions, I realized watching not this episode that they released today, the Do We Know Them, but the previous episode, the one on the Willy Wonka experience in Glasgow, or sorry, the Willy's Chocolate Extravaganza, or whatever it's called. they talked about the lawsuit. They gave a bit of an update at the end of it. And I realized now it's, it's very likely they don't watch me. They have linked to me so that they know I'm covering the case. But they probably hadn't watched the episode talking about Kitty from last week. And I realized I should probably do a little bit better job explaining where we are. Because, like I've said, I always like to, if I'm on a new case, I assume a new audience. Let's talk about the rules from scratch. And so even though we've talked about Rule 12b-6 a million times, let's do it again. Well, I realized from the way they were speaking that they may have had different expectations, shall I say. But basically, they said, where we are now is this isn't where we bring our evidence, and that this isn't the trial. This is where our lawyer says stuff. I can't remember exactly what they said. And Paul, you never sleep anyway, so, or at least Discord would lead me to believe you never sleep. So I'm not going to feel sorry for you over there in the UK on vacation visiting family that I'm keeping you up even later, or that you're up really early, But so yeah, basically these motions, the evidence itself doesn't matter. So the first time that evidence really matters is for a motion for summary judgment. That's where, think of that as the Pink Floyd motion. So I know you're all massive Pink Floyd fans, who isn't? Nope, Sublime today, not Pink Floyd shirt, but had to check. So one of the last tracks on the wall is The Trial. Erica, good to see you, even if you gave up on sleeping. But yeah, so one of the last tracks is The Trial. And the judge in a booming voice says, the evidence before the court is incontrovertible. There's no need for the jury to retire. So think of that as this, the summary judgment, the Pink Floyd motion, even though that would be more of a directed verdict since that's at trial. But you do a motion, you tell the judge the evidence is incontrovertible. There is no dispute of material fact. So you need to rule in our favor. So that's the first dispositive motion where the evidence actually matters. In a motion to dismiss, you're not actually looking at the evidence because you just assume it's true. You're not looking at the defense side of anything. The defendant is simply saying there is a defect in the pleadings. They have not brought enough evidence. They've left out an element that's necessary for their claim. So that's the difference between the 12b-6 motion, although it would also be 12b-1, the motion to dismiss for lack of jurisdiction, because remember, there's 3 elements in Rule 8. I've got that open. A pleading that states a claim for relief must contain a short and plain statement of the grounds for the court's jurisdiction. 2, a short and plain statement of the claim that the pleader is entitled to relief. And 3, a demand for the relief sought. So 12B1 is basically saying there's a defect in Rule 8A1. A 12B6 saying there's a defect in Rule 12B or in 8A2. So that's what we're at right here, is saying, hey, they haven't said fully what we've done. They haven't brought a good enough claim against us. Or in the SLAPP motion, once again, that's not about the evidence. That's about, hey, there's this law here that says I had a right to say what I said. So it's not a question of facts in that case. It's a matter of law. And if the law is on your side at the beginning, it's a short circuit mechanism so that you can get rid of the lawsuit before it even starts. So, so I don't have an example at the top of my head, but pretty much if you've ever watched a criminal trial, so like can't remember if Darrell Brooks attempted it or not, because he's dumb and pro se and a terrible person, but generally what you're going to do is, as the defendant, because there is no directed verdict for a guilty verdict, because you're presumed innocent, but basically after the prosecution rests, the defense attorney will get up and they'll say, Your Honor, we would like you to enter a directed verdict in favor of the defense. The prosecution has failed to state their case. There was one trial I saw, and it was just like a speeding ticket or something, drunk driving. It was something real small, can't remember what it was, where it was. I'm not going to dig it up, but the prosecutor forgot to identify the defendant. They forgot to have the cop, when they were testifying, the highway patroller, trooper, they forgot to have them identify the defendant. So the defense attorney said, Your Honor, I'd like you to move for a directed verdict. We don't know that this was my client. They haven't identified him, and the prosecution has rested. So rule in our favor. And the judge did. And the jury nullification was, well, I mean, technically, since he called witnesses himself. So the jury nullification bit with Darrell Brooks was after he put on his case. Now, the defense will ask for a directed verdict again after the defense case in chief, but they're going to do it both after the prosecution rests and before they put on their case, and then they'll do it again before it goes to the jury. So that's basically the place you see directed verdicts the most. So, but with that, let's jump into the documents. As I mentioned, we are doing Bekah Day first because that's the order it's in on the docket. And as I mentioned, I hate that this is separate documents, but this is Defendant Rebecca M. Day, nay Box's motion to dismiss pursuant to Federal Rule of Civil Procedure 12B6. Pursuant to Federal Rules of Civil Procedure 12b-6, and for the reasons stated in the attached memorandum in support, defendant Rebecca M. Day, nay Box, respectfully requests that this court dismiss plaintiffs Janet and Lauren the Mortician's complaint against her. And quickly moving on, and Brandon, that's why I do it. I mean, it's also fun to do, but you know, this is an educational channel, hopefully, first and foremost. It's, you know, when I do the late night videos, because generally if it's a recorded video, I'm starting about midnight here in Salt Lake. So, but the reason I like doing the live streams is you get the immediate feedback if, you know, if people have questions. So, you know, send me after those squirrels. But this is Bekah Day's memorandum of points and authorities in support of her motion to dismiss pursuant to 12b-6. And introduction. Plaintiff Janet filed this complaint against defendant Bekah Day in an improper effort to silence Day and other unrelated individuals who have independently voiced opinions about Braun, Janet, on social media that she deems unflattering. Janet contends that Day has defamed, in quotation marks, defamed her through posts and or stories that Day has posted on her personal account on the social media platform TikTok, in which Day has referred to Janet as unethical and rogue and expressed her subjective belief that Janet has filed false copyright strikes under the Digital Millennium Copyright Act, the DMCA. On behalf of, so she's expressed her subject belief that Janet has filed false copyright strikes under the DMCA on behalf of her clients, including her co-plaintiff, Lauren Probson, Lauren the Mortician. But she's also done it on behalf of Bunny XO and a variety of others, but that's not for today. But as explained in detail below, Illinois law is clear. Whether someone is unethical or rogue is so ambiguous and indefinite that it cannot be verified. Thus, such hyperbole is deemed to be a constitutionally protected opinion and not actionable as defamation. And as a side note, I really want to run the Rogue River in Southern Oregon. My dad did it like 45 years ago, 50 years ago, and it looks like it's such a fun river to do, but I think that one I'd need to get a guide because it's a wee bit bigger than the Snake that I'm used to, and it's a multi-day trip. The fact that these statements were made in the context of stories or comments Day posted on her personal TikTok account only underscores that they amount to nothing more than Day's unfiltered subjective beliefs. The same can be said for allegations that Janet files false copyright strikes. How would one go about verifying whether a lawsuit or other proceeding is false? As explained herein, Day believes the defamation claims asserted against her in this action are false. Does she open herself up to further defamation claims by expressing that opinion? I mean, no, because since there's ongoing litigation, that's privileged, but I get his point. Certainly not. Given that none of the statements on which Janet bases her defamation claim are actionable, Janet has failed to state a claim for defamation. And there's, you'll notice with Bekah Day, there are no claims brought by Lauren the Mortician. just Janet, because Laura or Bekah Day has not called, or at least, that we've seen, she's not made anything resembling calling Lauren the Mortician a turf, even though, no one has. They've just said, hey, she's liked videos from questionable people who appear to be turfs. Now, that's not calling her a turf, that's just saying she likes turfs, which is a different thing. But yeah, it's that this lawyer, Vitko, or however you pronounce his name, he's excellent. And I looked him up after last week's video, and I found it interesting. It's quite a combination. I knew he was a California attorney. He lives in California, but he is licensed in both California and Georgia. I don't know if that's something the girlies sought out, but considering he's arguing both the California anti-SLAPP statute and the Georgia anti-SLAPP statute, and 3/4 of his clients here live in one or the other of the states, that's quite a good combination of licenses, even if you had to be pro hoc vice in Illinois for this lawsuit. But he went, I think he went to Mercer Law. He went to law school in Georgia, practices in California, but he's excellent. Not only are the alleged defamatory statements on which this action is based non-actionable opinions, but they are subject to a qualified privilege under Illinois law, which requires that Janet plead facts supporting claims of actual malice. And hello, I am Raven. I'm not Artie. He was on earlier today, but I'm Joe. But go subscribe to Artie's Corporate Fiction too. He's entertaining and a lawyer on the East Coast. So, as Braun, Janet, has alleged nothing more than boilerplate conclusory allegations regarding Day's alleged malice, Janet has failed to overcome the qualified privilege. Accordingly, Day respectfully requests that this court dismiss Janet's defamation claim, along with the remaining defectively pled tort claims based on non-actionable defamatory statements under Federal Rule of Civil Procedure 12b-6. I complain slightly less about New Jersey than Artie. Of course, I live 2,000 miles from New Jersey. I probably complain about Utah as much as he complains about New Jersey, although I think I also love Utah more than he loves Jersey. I have a love-hate relationship with this state. I hate the government. I love the state. I think it's the third most beautiful state in the country. It's all right. Being compared to Artie shows I'm doing something okay. So, case background. Plaintiff Lauren Propson is a social media personality, and plaintiff Jeanette Braun, through plaintiff Braun IP Law, collectively Braun, or Janet, is her lawyer. So Imuji, now this is, like I've said, I don't talk politics on my channel, so you've got to take that out. But California is the most beautiful state in the country. It has everything. It has mountains that are just amazing. You know, Mount Whitney is so spectacular, it's unbelievable. You have deserts. The desert isn't everyone's cup of tea, but you've got Death Valley, less than 70 miles from Mount Whitney. You have the redwood forests. You've got beaches. You've got Big Sur. You've got everything. Number 2, I put Alaska. Number 3, I put Utah. Now, I generally prefer green to desert, but Utah's desert is just so spectacular that between, Bryce and Arches and Zion and, and Canyonlands, Capitol Reef, and those are just the national park. I think Utah should have 5 more national parks. And that's just the stuff I count that is on federal land. I think we should have 5 more parks, national parks. It's just ridiculous because, like, the Uinta Mountains, it's federal land, and it would be a national park in almost any other state. Bears Ears, Grand Staircase Escalante, the San Rafael Swell, what's it called? I can't think of what it's called, but it's right there by Brian Head. What? It's gonna bug me, but right by Brian Head, it's kind of it's like Bryce Canyon's little brother, but Cedar Breaks. That's it. Cedar Breaks. I think now it alone would be a very small national park, but there would still be at least 5 smaller. But there was a proposal a number of years ago to do a national park of Cedar Breaks and another area adjacent to it. And that would still be on the small end of national parks, but once again, it's all federal land already. So just right there, you've got 5 more national parks that are all spectacular. But so, like, my preference for if I'm spending time somewhere, like, I prefer the greenery of Hawaii to Utah's desert. But for sheer beauty to look at, I think Utah just has so much. And, West Virginia is all mountains. Debbie, Washington State. Washington State is gorgeous. The Olympic Peninsula, that's, that would be a dream to live there. But I just think Utah and California have a little of everything, and it's just an embarrassment of riches. And then Alaska is less diverse, but what it has is just so spectacular that, once again, it's ridiculous. So, and I haven't been to Zion since I was 6, I think. But it's gorgeous. My family tends to go north for vacations, so I mentioned the Snake River. We tend to go up Jackson Hole, Teton area, run the Snake River. Yellowstone's a hop, skip, and a jump over, and so that's what we tend to do. And I have been to the Lake District, but that's in Cumbria, not Lancashire. It's just north of Lancashire. But the Lake District is gorgeous. As most of you know, I lived east of there in Durham for a year. And yeah, Utah, best skiing, hands down. But let's get back to it. That was enough of that squirrel. So Propson is a licensed mortician residing in Wisconsin or maybe Florida, who operates a social media account on TikTok under the name Lauren the Mortician. Propson alleges that she has amassed millions of followers on TikTok, as well as sponsorships and monetization of the videos she posts of TikTok, including a brand partnership with a famous documentary channel. Propson alleges that her light-hearted and educational videos posted on TikTok discuss death, the loss of loved ones, and demystifying occupations and professions that work with deceased persons. But apparently, she also talks about the safety of car seats because she likes to pretend she's an expert in that as well. And tangents are fun. That's why, live streams. I mean, I realize this time of night I'm competing with Law and Lumber's Friday Night Frenzy, and I think you have to be diagnosed with ADHD to be on their show, pretty much. I've never been diagnosed, but I guarantee it's here. My niece was recently officially diagnosed, but they said no drugs for her unless and until it interferes with school. But, once again, it's official now. We've known forever. So Propson hired Janet, a lawyer, allegedly, to assist with her copyright infringement claims by filing a DMCA complaint to social media platforms hosting a video created by one of the defendants, who the complaint names as KC, the owner and operator of the social media account Caffinated Kitti, hereinafter referred to as KC. I mean, ever since Billy Mays died, even his infomercials were terrible. So, yeah. The complaint alleges that KC is a social media personality and is a citizen and resident of Georgia. Propson and Braun have asserted individual defamation and other tort claims against KC in this action based on statements allegedly made by KC on social media about Propson and after the filing of the DMCA copyright strike against her about Janet. And Debbie, it always sucks when one medical condition interferes with the other. I mean, the medical conditions themselves can suck, but competing is never fun. In addition to asserting defamation and other tort claims against KC, plaintiffs have also named other defendants based on alleged defamatory statements these individuals purportedly made on social media, including Day. The complaint alleges that Day is a social media content creator known as Bekah Day, who holds herself out to be an unbiased content creator and an independent investigative reporter. The complaint alleges that Day is a citizen and resident of the state of Missouri. The complaint further alleges that in November 2023, defendant Day made content regarding defendant Casey's claims about Ms. Propson and attorney Janet, on which plaintiffs base their claims. And that's true, Surrender Monkey. So when I went to the Lake District, it was when my parents came to pick me up at the end of my master's degree, and our base for exploring the Northwest was a little itty-bitty dot on the map called Carnforth. They're in northern Lancashire, and we never made it into Blackpool. We went to Morecambe and Lancaster when we went south, but mostly we went up north. And I like driving mountain roads, but not being used to driving on the other side of the road made it interesting. So, yeah. Yeah. Especially with the stacked stone walls on those narrow roads. That made it really interesting. Defendant Day's alleged defamatory statements. Day allegedly created and posted videos stating the false claim that attorney Braun files false copyright strikes, is unethical, and is a rogue attorney. In support of this allegation, the complaint sets forth a screenshot of a reply to a comment allegedly posted by Day stating, I posted proof on my page that your legal name is attached to the false copyright strikes. Don't know why you are behaving like this on the internet. The complaint does not identify to whom the comment is directed, when the comment allegedly was posted, or where on the internet the comment allegedly was posted. So Janet would be a terrible journalist, you know. Who, what, where, when, why, how. None of those, other than, you know, that Bekah Day is the one that allegedly did it. But when, where, to whom? Who knows? The complaint also sets forth a screenshot of what appears to be a social media post by Day, in which Day states there are a group, creators on this app who have weaponized Janet's aggressive, threatening, and unethical tactic to scare creators off the app. I have a list of creators who have utilized Janet and another list of creators who have been wrongfully impacted by false copyright strikes sent in by Janet. This is just the beginning. Shocked and applauded. Should be appalled, but, you know, that's probably autocorrect. To see women I'm mutuals with hiring this woman to do their dirty work. 'Tis the season of exposing, I suppose. The complaint does not allege where on the internet the statements were posted or when the statements were posted. The complaint further alleges that in a since deleted video from TikTok, Day stated the following, but I just want to make it very clear that my position is to ensure that there is not a rogue attorney on this app. Oh yeah. Oh yeah. You absolutely laugh at the opposition if they're dumb. You laugh at clients if they're dumb. I mean, you know, sovereign citizens, you know, we cover sovereign citizens on this channel, absolutely detest lawyers. They hate hiring lawyers. But I worked at a firm that did criminal defense and plaintiff side employment law. I had a sovereign citizen come in and he wanted to hire us for employment law based on his sovereign citizen beliefs about the Fourth Amendment applied to employment law. I sat and talked to him for an hour because I thought it was absolutely hilarious. I mean, it was an hour I'll never get back. I didn't get paid for that hour, but it was hilarious. So instead of shooing him out real quickly, sorry, I can't help you, I sat there and listened because it was hilarious. And that's the way they need to be treated in court, frankly. The way Judge Simpson did, the way Judge Washington does it. Basically, you know, if you don't identify, hey, bench warrant, you're not here. We'll identify you at the jail. So, but yeah, moving on. Finally, the complaint alleges that, or before we move on, I saw Van Balen has the update on Eddie Alexander Banks. Since I'm so far behind, I haven't covered his last court appearance yet, which I will, but Eddie Alexander Banks has been caught. So Now moving on. Finally, the complaint alleges that Day posted a video or a story on TikTok stating the Illinois Attorney Registration and Disciplinary Commission told Day they received multiple credible complaints about Janet and that they have assigned multiple attorneys to investigate this matter. The complaint contains no allegations that this statement is false. Rather, it states that upon information and belief, the Attorney Discipline Committee does not comment or provide input on the merits of an investigation to anyone calling to inquire about a registered attorney. And upon information and belief, the Illinois Registration and Disciplinary Commission would only confirm whether or not the attorney in question was registered, convey the date they were registered, share if the attorney is in good standing, and share if the attorney has ever been found to have engaged in misconduct. And we have footnote 1. The complaint contains other allegations regarding Day's purported conduct directed at other individuals who are not parties to this action, the Demps person, and have no bearing or relation on any alleged statements made by Day regarding either of the plaintiffs. And the complaint at paragraph 57 has allegations regarding statements Day allegedly made about the singer Diplo that has no connection with either Janet or Propson. Paragraph 71, an allegation regarding a video that Day allegedly posted about a former client of Braun, Caitlin Demps, but that does not allege what Day stated in the video or how it was in any way defamatory to Janet or Propson. So, yeah, there's that. The complaint is devoid of any allegation that Day has made false or defamatory statements about Janet. And yeah, she'll just, maybe feel good about herself if we call her Jeanette by accident. So we've got to make sure it's Janet. Got to make sure. Besides, if we talk about Janet, we're not talking about you, Janet. But yeah, either way, it's fun. So, as this says, the complaint is devoid of any allegation that Day made false or defamatory statements about Propson. But it's so there's no claims for Lauren the Mortician against Bekah Day. But frankly, it's devoid of any allegation of actual false or defamatory statements against Janet, because it's all, oh, she hurt my fifis, she called me unethical, and opinions, are bad, so I'm going to sue. Opinions are non-falsifiable, so they can't be defamation. But, you'd think a federal civil attorney would understand that. So, argument, legal standard. Under Federal Rule of Civil Procedure 12b-6, a defendant may move to dismiss for failure to state a claim upon which relief can be granted. See Federal Rule of Civil Procedure 12b-6. And footnote 2, Day has not moved to strike the claims asserted against her under anti-SLAPP law, as the other defendants have, because the state of Missouri, where the complaint alleges Day resides, has not enacted an anti-SLAPP statute that would apply to the statements at issue. Hey, remember when I said that at the very beginning before we even looked at this document, when we were just on the docket? So, yeah, basically that's what I said. That's what I thought. And Luna Knights, yeah, truth is an absolute defense. But like I said, if it's non-falsifiable, how how can you prove? You know, how can you prove it's false? So that's why, you know, hyperbole, opinion, that's all. You know, if I say there is no God, the Catholic Church can't sue me for slander for calling them liars because it's non-falsifiable. That's not what I'm doing here. I'm just using that as an extreme example, of course. But you know, it's as we saw last week. I'm sure we'll see it here today. You know, calling someone a racist, calling someone a bigot, that's frequently not actionable. It may hurt your feelings, but whatever. Hurt feelings aren't a valid cause of action. So, in determining whether a complaint satisfies Rule 12b-6, the court accepts the facts stated in the complaint as true and draws reasonable inferences in plaintiff's favor. That's Parrish versus City of Elkhart, 7th Circuit, 2010. And yeah, some people, I think, haven't heard of free speech. You'd think a lawyer would have by now, but, you know, she doesn't seem to be a very good lawyer, so maybe she skipped that day of constitutional law. Although we spent a lot more than one day. Well, at least a lot more than one day on the First Amendment. But yeah. Though a complaint need not contain detailed factual allegations, a formulaic recitation of the elements of a cause of action will not do. And that's our old friend Twombly, Supreme Court, 2007. Rather, the complaint must contain enough facts to state a claim to relief that is plausible on its face. A complaint fails to state a claim where the well-pleaded facts do not permit the court to infer more than the mere possibility of misconduct. And that's Twombly's sister case, Iqbal, from 2009. Here, as explained below, plaintiffs have failed to state facts sufficient to constitute any cause of action against Day. It's a possibility, Luna Knights, because you know, we're all scratching our heads to figure out what she means by federal civil attorney, because that's how she, you know, announces herself. It's, you know, I think in her head she has a trumpet fanfare as she says she's a federal civil attorney. And to me, it's like, well, whoop-de-doo. So you paid an extra $25 to be admitted to practice in the federal court. But to the uninitiated, it's like, oh, so you work for the federal government? And I think that's kind of, she's using it as a play for authority, and there is no greater authority than the federal government. So yeah. Neil Morrison, good morning. It's like I said, I'm doing this later than I normally do, but I figure not everyone lives on the East Coast of the US, so works better for some people. And it's what worked for me today. So the complaint does not state a claim for defamation against Day. To state a claim for defamation under Illinois law, footnote 3, under Illinois law, the law of the state where the injury occurred governs the substantive issues of the case, and that's Townsend versus Sears Roebuck, Supreme Court, 2007. Or no, sorry. That would be the Illinois Supreme Court, 2007. And in the case of defamation, that is the state in which the plaintiff is domiciled. See Camelgard versus Macura, 7th Circuit, 2009. Here, as explained above, the complaint alleges that Janet is a resident of Illinois, even though she's actually probably domiciled in South Carolina, is licensed to practice law in Illinois, and operates her law firm in Illinois. Further, Braun IP law was organized and exists under Illinois law. But it's a sole member LLC, so it's probably also domiciled in South Carolina, where its only member is probably domiciled, but we won't worry about that too much here. But remember, they're clearing this up. They're stating this. For the defamation, for the actual causes of action, Illinois law controls. But for the anti-SLAPP motions, the defendant's and resident, anti-SLAPP law applies. So not the Illinois law. So even though this doesn't contain an anti-SLAPP motion, this one, Bekah Days, because Missouri doesn't have one, they're still hammering it home. For this, Illinois law controls. For other stuff, California and Georgia controls. So that's why they kept that in here. So to state a claim for defamation under Illinois law, a plaintiff must plead facts showing 1. The defendant made a false statement concerning the plaintiff. 2. There was an unprivileged publication of the defamatory statement to a third party by defendant. And 3. Publication of the defamatory statement damaged the plaintiff. And that's Brennan versus Kadner, Illinois Court of Appeals, 2004. And we don't know where most of this was published because Janet hasn't told us. But, it's also the whole false statement concerning Janet also doesn't exist because it's like my opinion, man. So count 3 of the complaint asserts a claim for defamation per se by Janet against Day based on Day's alleged statements that Janet was unethical and that she files false copyright lawsuits without proper investigation, and that Day used her platform to attack Janet's character and reputation. The complaint does not include any claim for defamation asserted by Lauren the Mortician against Day. Janet fails to state a claim for defamation against Day for a variety of reasons. Ooh, that's he's going hard here. She doesn't just fail to state a claim for a reason, it's for a variety of reasons. So yeah, it's this time of year, Surrender Monkey. It's cold up there in Scotland, so you've got to wake up when your sheep wake up, because you get cold once they leave the bed. It's that woolen blanket, live wool blanket, and all that. Different reason in Wales, of course, but we won't go into that. I love you, Wales. I've never been, but you're all right by me. You can say a lot about Utah too. Day's alleged false copyright lawsuits, unethical and rogue statements are non-actionable opinions. The complaint alleges that Day defamed Janet by publicly stating that Janet files false copyright lawsuits and is unethical. Footnote 4. The complaint also alleges that Day defamed Janet by using her platform to attack Janet's character and reputation. This allegation cannot support a claim for defamation because Janet fails to identify any specific statements allegedly made by Day. See Osundaro, which was dismissed defamation and false light claim because plaintiffs do not identify any particular statement that forms the basis for this allegation. This imprecision leaves defendants and this court guessing as to which statements are at issue. Thus, the vague allegation that Day attacked Janet's character and reputation without precise identification of the actual words used by Day makes it virtually impossible for Day to formulate a responsive pleading and should be dismissed for lack of specificity. It's like delete laws. Well, you know, I've got a valid Monell claim against LVMPD. I don't know any of their actually unconstitutional policies, but believe you me, there is one or multiple. Find where I was. The complaint alleges that Day defamed Braun by publicly stating that Braun files false copyright lawsuits and is unethical. However, such statements are non-actionable, as they constitute constitutionally protected opinions rather than verifiable statements of fact. A statement is constitutionally protected opinion if it cannot reasonably be interpreted as stating actual facts about the plaintiff when viewed from the perspective of an ordinary reader. That's Doctors Data versus Barrett, Northern District of Illinois, 2016. See also Moriarty versus Green, Illinois Court of Appeals 2000, which says only statements capable of being proven true or false are actionable, opinions or not. So let's read that again, because I kind of read it weird and didn't put the proper emphasis on it. Only statements that are capable of being proven true or false are actionable, whether they're opinions or not. So if you make what appears to be a factual statement, but it's non-falsifiable, it's incapable of being proven true or false, it cannot be defamation because it can't be proven true or false. So God is real or God isn't real can't be proven true or false. It's non-falsifiable. Therefore, it can't be the basis for defamation. So calling someone a TERF, I can't prove what's in Lauren the Mortician's head. So it's non-actionable. Saying Janet is a rogue attorney. Well, first of all, what the hell is a rogue attorney? That's vague. But, or saying she files frivolous copyright strikes. Well, that would depend on whether Janet believes it's frivolous or not. And we can't prove what's in that noggin of Janet's. So we don't know. It's non-falsifiable. And it's amazing to me. Another tangent. But so delete laws, apparently, as you know, I don't watch him. But I did see this surrender monkey in the Chili Watch Discord on Masshole's Discord that he claims, because you know his followers are brain dead idiots. They believe they think he's already won because he says he sues people for a living. They think he's already won, but he tells them, "Oh yeah, I'm gonna get a 7-figure settlement." No, you're not. No, like at this point, they fought it enough. They're not going to settle, I don't think. Like, and go away money for a settlement is like a couple grand. This is such a loser of a case, though, and it would set such a bad precedence for LVMPD. This is one they're fighting, and you're not winning it at trial. But I see once again on the Discord, he's trying to get, I guess, I don't know, something from I haven't read the entire Discord chain, but he's FOIAing, doing a Freedom of Information request, trying to get something about a lawsuit where someone did win $1.5 million from a police department because they were wrongfully tased. And he thinks if he takes that complaint and files it as his own, that it'll make his case $1 million winner. But it won't, because his facts are different. His facts are terrible. And you know, I remember he tried this in the Massachusetts case. I don't remember the exact context because it was over a year ago, but I think it was one of his motions for sanctions or the motion for recusal, I think, to try and get Judge Sugartits recused. And he was like, well, this was a motion that I copied a motion that won getting that other judge recused. So if you don't recuse yourself when I used this winning motion, it just shows that you're biased and need to recuse yourself. And it's like, but it won because their facts worked. Yours don't. It's facts and law. You can't just submit a boilerplate motion and say, well, this motion has worked before. If the facts are different, it's not going to work. But he is too stupid to understand that. So, and he frankly, if he weren't pro se, he would have been sanctioned more, because if he weren't pro se, he'd have adverse findings against him by now in the discovery fight. So, but back to Braun, Janet, our lovable or not so lovable scamp. To determine whether a statement is factual in nature, Illinois courts consider whether the statement has a precise and readily understood meaning, whether the statement is verifiable, and whether the statement's literary or social context signals that it has factual content. If it is clear that the speaker is expressing a subjective view or interpretation, such as when the speaker discloses the facts forming the basis for their statement, the statement is not actionable as defamation. That's from Doctor's Data. So it's not just expressing it, it's subjective view or interpretation. So Bekah Day's interpretation was that Janet files false or frivolous copyright strikes. So it's just bad. It's just bad. And Grifkai refiling a case that has already been dismissed, that's a speed run to sanctions. It's not going to work out well for him. So here, Day is expressing her subjective opinion that the copyright claims filed by Braun lacked substantive merit. C.E.G. McGurran versus Hubbard Radio Chicago, Northern District of Illinois, 2022, which was a statement by employer that it disagreed with plaintiff's characterization of events underlying EEOC claim was a classic statement of opinion. Moreover, the term false is not verifiable because it has no precise and readily understood meaning. What does it mean for a DMCA copyright claim or strike to be false? That it lacks merit? And by whose standard? Does it mean that there are substantive defenses that the content creator at whom the strike is directed can assert? Or that the claim was filed for an improper motive? The term false is so broad in scope that it lacks the necessary detail to have a precise and readily understood meaning required to be actionable. See Hopewell versus Vitullo, however you pronounce that, Illinois Court of Appeals 1998, which held that the term incompetent is a non-actionable opinion because there are numerous reasons why one might conclude that another is incompetent. One person's idea of when one reaches the threshold of incompetence will vary from the next person's. Wow. Whoa. So if we were hypothetically to say that Janet is an incompetent attorney, that would be non-actionable because incompetent, according to Hopewell versus Vitullo, however you pronounce it, incompetent is non-actionable. I'm not telling you to call Janet an incompetent attorney, but if you were to come to the conclusion in your own mind that Janet Braun is an incompetent attorney, she couldn't hold it against you legally. So it's also Green versus Rogers, Illinois Supreme Court 2009, which held the word misconduct was too general and imprecise to constitute actionable defamation. Solia Tech versus Specialty Publications Company, Illinois Court of Appeals 2006, or Illinois Supreme Court 2006. The phrase deeply greedy people has no precise meaning, and it is not verifiable. Further, the context in which that phrase appeared indicates that it may have been judgmental, but it was not factual. So, theoretically, if I were to say Jeanette Braun is a deeply greedy person who expresses her deeply greedy tendencies by filing incompetently prepared false copyright strikes. If I were to say that, it would be non-actionable. So, I mean, there's that. I'm not saying that. But if you were to come to that conclusion, it would be non-actionable according to Illinois case law. So you've got to give Janet some credit. I don't think her law license came from a cereal box. I think it's a Cracker Jacks box. Give her some credit. Individuals speak out all the time regarding the merits of pending litigation, whether it is the litigant, him or herself, a legal commentator, such as moi, etc. Under Janet's distorted interpretation of the law, a lawyer would have a claim for defamation anytime an individual publicly disagreed with the merit of a claim the lawyer filed. That cannot be the law. Likewise, whether a person's actions are ethical or deceptive is not objectively verifiable. That's Tamburo versus Dworkin, Northern District of Illinois, 2013, which cites Lifton versus Board of Education of the City of Chicago, 7th Circuit 2005, which held that the Illinois Supreme Court has filed that calling someone a crook or incompetent was non-actionable because such bare statements contain no verifiable factual information. Then law offices of David Frayden versus Chimara, 7th Circuit 2022, held that generally calling someone a chauvinist or racist is a non-actionable statement of opinion. Thus, such allegations cannot state a claim for defamation. And that same case dismissed claims for defamation based on non-actionable opinion. Here, the complaint makes clear that Day's alleged reference to Braun as unethical is based on Day's subjective opinion of Janet's aggressive, threatening, and unethical tactic to scare creators off the app by filing false copyright strikes. Again, whether Janet has filed false copyright strikes is not objectively verifiable, as explained above, nor is whether Janet is using aggressive or threatening tactics. What is aggressive, threatening, and unethical to one person may not be to another. That's law offices of David Frayden again, where the claim was dismissed, dismissing defamation claim based on statements made on the internet about a law firm because there are numerous reasons why someone may have had a terrible experience or suggest that a product or service would be a waste of money. As the Seventh Circuit has held, legal representation is attended by a great deal of uncertainty. Excellent lawyers may lose most of their cases because they're hired only in the most difficult ones, while poor lawyers may win cases because they turn away all the ones that would challenge their meager abilities. And that's why when, like, look at Michael Mee, for example, Delete Law's lawyer in Vegas. He advertises 100% success rate, but that's because, number one, he seemingly avoids trial, and so it means he pleads them out so he doesn't lose trials, but he also takes the easy cases. Whereas, the best criminal defense lawyers in most jurisdictions are going to be the public defenders, because they're trying cases every week, every day even. But their win-loss record is going to be abysmal versus the high-dollar attorney that turns away 9 cases out of 10 to keep his stats up. Whereas the public defender they're handed the shit sandwich cases. That they're unwinnable, and because they're unwinnable, the client has nothing to lose by going to trial. So it goes to trial and they lose. Like, the can't remember if it was today or yesterday. I'm gonna ask him for the raw video of this, but Colin, definitely not Cromwell. There was a pro se trial earlier, either, like I said, it was either today or yesterday, down in Bay County, Florida. Guy was, he was obviously convicted of dealing meth, but frankly, he had nothing to lose by going pro se because the public defender was going to lose it too. By the time it got to trial, if she hadn't been able to suppress the stop, the trial was going to be lost, period, because the facts were against them. The law was against them. If they hire me, it's like, well, we're not going to win. You need to take the deal. I cannot win this trial. High dollar attorneys that they'll they'll look at it and they'll say, yeah, what do you want me to do with this? You're guilty. We can't win this one. You're you can spend thousands of dollars on me, but I'm going to tell you to take the deal because you're we can't win. Whereas the public defender, they're stuck with it unless the person goes pro se or doesn't qualify for a public defender for some reason. But that guy definitely qualified for a public defender. Let's just but yeah, so either way, this attorney has an excellent point. Terrible lawyers can have great stats by choosing their cases carefully. Whereas, the death penalty qualified attorneys are generally going to be the best defense attorneys. Their records are going to suck a lot of the time because by being death penalty qualified, they're taking the hard cases. So, who do you want? The guy that wins everything but doesn't take good, hard cases, pleads everything out? Or do you want the person who's experienced and is going to fight for you and, maybe has lost more than he's won, but he's really gone to bat for his clients and done a great job? So, there we are. Many lawyers are good at some things and poor at others. So, Michael me might actually be good at negotiating those pleas. So it's like, yeah, he may not go to trial. He may negotiate such fantastic plea offers that his clients would be dumb to not accept them. So he might be the absolute best, the plea deal savant, but not good at trial. I'm just guessing. I don't know. Just hypothetical. So many lawyers are good at some things and poor at others. So that the evaluation of them will depend on what the evaluator is interested in. It would be unmanageable to ask a court, in order to determine the validity of the defendant's defense of truth, to determine whether, in fact, Sullivan from Sullivan versus Conway is a poor lawyer. So Sullivan versus Conway, 7th Circuit, 1998. The same can be said as to whether a lawyer is aggressive, threatening, unethical, or files false claims. Indeed, in Black versus Wrigley, Northern District of Illinois, 2017, the district court granted a motion to dismiss a defamation claim based on alleged statements that a lawyer and law professor acted unethically during litigation and is unfit to be a law professor, finding the statements to be non-actionable expressions of opinion. I'd only say that about one of my law professors, but he was a pretty big dickhead. The district court reasoned that these alleged statements are interpretations or characterizations of other facts defendants disclosed, and therefore non-actionable. That's Wrigley, which cited Patlovich versus Rudd, Northern District of Illinois, 1996, which put subjective labels like reprehensible and self-serving on previously described factual assertions, does not add any new facts, and is pure opinion. The same can be said for Day's characterization or interpretation of Janet's filing of DMCA strikes as false or unethical. As for the allegation that Day stated her intent to ruin Janet's career as a social media lawyer, the only factual allegation supporting this claim is an alleged statement by Day that she wants to ensure that there is not a rogue attorney on this app. Nowhere does Braun identify a statement made by Day that she wanted to ruin Janet's career, and calling Janet a rogue attorney is a non-actionable opinion for the reasons set forth above. And that's Patlovich again. See also Hopewell, Illinois Court of Appeals, where a statement was non-actionable opinion because it was so ambiguous and indefinite that the veracity of the statement could not be verified. Imperial Apparel versus Cosmos Designer Direct, Illinois Supreme Court 2008, where specifically the First Amendment prohibits defamation actions based on loose figurative language that no reasonable person would believe presented facts. The problem here is no reasonable person would believe presented facts. Janet, I don't think, is a reasonable person. That's my subjective belief. It's based on what I've seen, but it's my subjective belief that Janet is not a reasonable person, especially not a reasonable lawyer. Moreover, under Illinois law, social contexts are a major determinant of whether an ordinary reader would view an alleged defamatory statement as constituting fact or opinion. That's Brennan versus Kadner, Illinois Court of Appeals, 2004. Thus, where potentially defamatory statements are published in a setting in which the audience may anticipate efforts by the parties to persuade others to their positions by the use of epithets, fiery rhetoric, or hyperbole, language which generally might be considered as statements of fact may well assume the character of statements of opinion. And that's still from Kadner. So basically, you know, if you go on, let's say, the Chili Watch Discord, where you're pretty much guaranteed epithets, fiery rhetoric, and hyperbole. So maybe language posted in there that generally would be considered as statements of fact should consider, you know, as statements of opinion, or really in their satire. But Delete Laws doesn't seem to understand that, because he seems to think it's all a vast conspiracy against him for that. So, yeah. For example, in Brennan, the court found the defendant's statements could not be construed as a literal assertion that the plaintiff had committed mail fraud because the alleged defamatory statement was made in the literary context of a regularly featured column by a journalist who regularly expressed his personal opinions on a wide range of public and social issues. So it's like here in Salt Lake, the Salt Lake Tribune used to have a columnist named Robert Kirby, and he wrote, you know, it was social commentary in his regular column, but there was a heavy dose of sarcasm and satire in it. So you couldn't exactly take most of what he said as factual. Of course, with him, most of the objectionable comments were made about himself and his wife. So, you know, at least it was mostly self-deprecation. Surrender Monkey, how dare they forget, you know, to prove Delete Laws right? I think. Wait, no. So see also Freyden, which held that we must consider the particular social context of these online reviews and what it may signal about their contents. The defendants posted their reviews on Facebook, Yelp, and Google pages, which invite unfiltered comments. We trust that readers of online reviews are skeptical about what they read. both positive and negative. Now, I've never really put a whole lot of stock into the online reviews because, you know, I've, well, first of all, I've never been driven to, I've loved this so much, I must write a review. I've written one Yelp review, and it was a local brew pub. I got fish and chips. I The service was terrible that night, and I equated it to a glazed Twinkie, or sorry, a fish Twinkie. It was bad fish and chips, and I was mad. I'm never going again. And they're like, give us your email. We'll send you a gift certificate. And I didn't follow through, but it was one of my law school classmates' favorite hangout. So I actually did go back, and turns out they had decent pizza. I never tried their fish and chips again, but that's the only time I've ever felt compelled to leave a Yelp review. But like Google, the law firm I mentioned earlier that I worked for, each client, my boss would ask them, hey, if you're happy, will you leave us a 5-star review on Google and Yelp? And he was getting so many 5-star reviews that Google said these have got to be fraudulent. So they wiped away all of his 5-star reviews and only left the negative ones, because they said, well, the negative ones have got to be true. The 5-star ones, though, you coerced them. So that told me everything I needed to know about reviews. But we trust that readers of online reviews are skeptical about what they read, both positive and negative. Here, the complaint alleges that Day is a social media content creator, and the alleged defamatory statements were made in connection with posts and stories Day created to post on her own TikTok account. Given this context, followers and/or other social media users would understand Day's statements to be her own unfiltered, subjective views. And footnote 5. Indeed, courts have emphasized the generally informal and unedited nature of statements made on the internet. See Gansky versus Mensch, Southern District of New York, 2020, citing Sandals Resorts International versus Google, in 20. Yeah. Okay, sorry. So the Sandals Resorts versus Google was in the New York Supreme Court, which is their trial level court, in 2011, which says the culture of internet communications, as distinct from that of print media, such as newspapers and magazines, has been characterized as encouraging a freewheeling, anything-goes writing style. It's the Wild West. Social media platforms are equally, if not more, informal and freewheeling, and as such convey a strong signal to a reasonable reader that a statement is opinion. And that's referring to statements on Twitter. So basically, it's, the internet's the Wild West. Social media is literally outside of the OK Corral. You're looking for a dust up. So next up, Day's alleged false copyright lawsuits and unethical statements are subject to a qualified privilege. Allegations that Janet is unethical or files false copyright claims are subject to a qualified privilege under Illinois law. Such a privilege may exist where the situation involves an interest of the person who publishes the defamatory statement or an interest of the person to whom the matter is published. That's Tamboro, citing DePinto versus Sherwin-Williams, Northern District of Illinois, 2011. Courts also recognize as privileged communications involving a recognized public interest. Whether a qualified privilege exists is a question of law for the court. So not a question of fact, it's a question of law. Day's statements are privileged because they relate to her interest in protecting her freedom of speech in her social media posts and in not being subject to DMCA copyright strikes filed by Janet in response to statements made on social media with which Janet's clients disagree. And frankly, Bunny XO, like if this were to go to trial, I'd be trying to get Bunny XO on the stand. Not saying I'd be able to, but I'd be trying to, because on her podcast, she's admitted that's how she has used Janet as a bludgeon. That she doesn't care if it's a copyright strike or not. It's they said things I don't like, so therefore strike. Moreover, the statements made by Day were published to those who share that interest, i.e., other individuals who have social media accounts who have been or could be subject to DMCA copyright strikes filed by Janet. Thus, under Illinois law, these statements are subject to a qualified privilege. See Tamburo, which held that alleged defamatory statements made by the owner of a dog breed database website that plaintiff stole her data and was unethical or subject to qualified privilege because they related to her interests in protecting the substantial time and effort spent accumulating her data and making it freely available to the community of dog breeders to promote the health of the breed. And the statements were published to people who likewise had an interest in the way in which the dog pedigree data was made available, and they involved a public interest in how access to information available on the internet is regulated. And also Haywood versus Lucent Technologies, Northern District of Illinois, 2001, which was affirmed by the Seventh Circuit in 2003, held that defendant's statement that former employee was unstable to building security and other employees was privileged said she was unstable. The former employee was unstable, and it was said to the building security and other employees, and that statement was privileged because the defendant, security guards, and other employees have a compelling interest in knowing that the plaintiff was terminated and no longer allowed on the premises. Then Ludlow versus Northwestern University, Northern District of Illinois, 2015, held that a student's statement to the university regarding an alleged sexual assault by an employee clearly implicates both her interest in her own safety and the university's interest in student safety and the resolution of claims against its employees. So, yeah, that sounds like an interest. Did I know that in the UK, any fines ordered by the courts will not be reversed because of a sarcastic review, even after the police testimony was false and subsequently arrested for corruption? I did not know that. That sucks. Yeah. Oof. That's no good. Once qualified immunity has been identified, a plaintiff may overcome this challenge at the pleading stage by alleging the statement was made with actual malice, either knowledge of its falsity or in reckless disregard of the truth. Courts in this district, however, have looked for something more than conclusory statements in order to infer the defendant knew the statements were untrue or recklessly disregarded the truth or falsity of those statements. And that case also found general allegation that the defendant made false statements during the 2014 investigation, knowing those statements were false, was inadequate to overcome qualified privilege. Also, Unsundiro where it was held that the bare conclusory claim of malice, unaccompanied by allegations from which the required subjective element of malice might be inferred, is insufficient to survive a motion to dismiss. Here, the complaint contains nothing more than the conclusory statement that Day's defamatory statements were made with knowledge of their falsity and with a reckless disregard for the truth. That's a conclusory statement. There are no facts alleged to support this boilerplate allegation, and without such facts, Janet cannot overcome application of the qualified privilege. That's footnote 6. The complaint does allege that Day did not conduct any investigation that involved fact-checking or reaching out to knowledgeable parties to verify the information in her posts, and never contacted plaintiff to verify the information in her posts. However, a failure to investigate does not itself establish actual malice if the defendants did not seriously doubt the truth of their assertions. That's Hardiman versus Aslam, Illinois Court of Appeals, 2019. The complaint contains no factual allegation establishing that Day seriously doubted the truth of her statements. Next up, Day's alleged statement regarding information from the Illinois ARDC is not actionable. The complaint alleges that Day posted a TikTok story in which she stated that the Illinois Attorney Registration and Disciplinary Commission, the ARDC, told Day they received multiple credible complaints about Janet, and they have assigned multiple attorneys to investigate this matter. It is unclear whether Janet's defamation claim is based on this allegation, as Count 3 refers to only the unethical and false copyright claim allegations. Regardless, such a claim is not actionable. First, there is no allegation that this statement is false, and a false statement is an essential element of a defamation claim. That cites Partridge versus Loyola University of Chicago, Illinois Court of Appeals, 2019. Nowhere in the complaint does Janet allege the ARDC did not tell Day that it had received multiple credible complaints about Janet and is investigating the matter, or that the ARDC did not actually receive multiple credible complaints. Without such an allegation, Janet cannot state a claim for defamation. And footnote 7. Rather, the complaint alleges only that upon information and belief, the ARDC generally does not comment or provide input on the merits of an investigation and would only provide limited information to individuals calling to inquire about a registered attorney. The complaint further alleges that as of its filing, Janet has 0 misconduct violations on her record. None of these allegations establish that Day's statement is false. Second, a republisher, as Day is here, cannot be held liable unless the plaintiff establishes by clear and convincing evidence that the statement was published with actual malice. That is, with knowledge that the statement was false or with reckless disregard as to whether it was false. That's Brennan versus Cadner, Illinois Court of Appeals, 2004. So basically what that's saying here is Bekah Day is a republisher of that statement. It's the ARDC that made the statement that Janet has received multiple complaints and they're investigating her. Bekah Day just shared it, republished it. So unless she had actual malice in republishing it, and if she did get that statement from the ARDC, well, then it's straight from the horse's mouth. And how could she have actual malice to not believe that it's true straight from them? So she's republishing it. Here, Day is merely republishing statements allegedly made to her by the ARDC. Thus, Janet must allege facts establishing actual malice. As explained above, the complaint is devoid of any factual allegations to support its conclusory claims of knowledge of falsity or reckless disregard for the truth. Its bare bones boilerplate allegations are insufficient. Third, the statement is subject to an innocent construction. The innocent construction rule requires the court to adopt an innocent construction of allegedly defamatory statements if such an interpretation is reasonable, and that's from McGurran. A statement that the ARDC is investigating Braun does not, in and of itself, indicate that Braun has committed professional misconduct. Given that this statement is subject to an innocent construction, Janet cannot state a claim for defamation based on it. So the innocent construction would be, yeah, we've received a whole bunch of complaints about her after the Caffinated Kitti video, after she filed her copyright strikes against Caffinated Kitti. We received a bunch of complaints and we're investigating them. So the innocent construction is, hey, yeah, we received what might actually be, I get the irony here, but we received what might be false complaints and we are investigating them. The investigation might be to clear Janet. We don't know, but that's an innocent, innocent construction. It doesn't mean, oh yeah, we've received a whole bunch of complaints. You just wait. Disbarment starts Monday. That's not the only construction of this. But what do I know? The complaint does not state a claim for false light or trade libel against Day. Because Janet has failed to state a claim for defamation against Day, its false light and trade libel claims against Day, arising out of the same allegations of defamation, must fail as well. See e.g. Madison versus Frazier, 7th Circuit, 2008, when an unsuccessful defamation per se claim is the basis of a plaintiff's false light claim, his false light invasion of privacy claim fails as well. Next up, the complaint does not state a claim for tortious interference against Day. And someone asked me, the Vangelina Skov, she is a commentary YouTuber, kind of same space as Do We Know Them, a couple others. Hodgepodge Harmony, good to see you. But plagiarism seems to be like the go-to accusation on YouTube right now. And the standard for plagiarism on YouTube is, I think, a different standard than academic plagiarism. But in a post-Illuminati and James Somerton world, I think plagiarist is the new predator. You want to discredit someone, you call them a plagiarist. So another creator accused Vangelina of plagiarizing his old video and emailed one of, I think it was HelloFresh, one of Vangelina's sponsors, well, specifically the sponsor for that video, saying something to the tune of, hey, she plagiarized on that video you sponsored, therefore you should stop contracting with her or give me money or something, whatever, fuck you. And so someone asked me, I can't remember who it was, but someone asked me, would that be tortious interference with a contract? And maybe. I don't have enough information on that because number one, that specific contract for that video has been completed. So for that, probably not. But if they knew that there was an ongoing expectation or ongoing negotiations for further contracts and those contracts suddenly stopped, then it could be. Now, that's of course me using US law. Evangelina Skov is in Ireland, so it's harder to say. So, you know, I hate to say it, but maybe it depends. That's the standard lawyer answer for a reason. But yeah. So Janet has asserted a claim for tortious interference with existing and potential business relationships against all defendants, including Day, based on allegations that Day's defamatory statements have caused and are likely to continue to cause the public and content creators not to employ Janet for legal representation. Under Illinois law, a claim for tortious interference with prospective economic advantage requires that plaintiffs show 1. Their reasonable expectation of entering into a valid business relationship. 2. Defendant's knowledge of that expectancy. 3. Purposeful interference by the defendants preventing that expectancy from being fulfilled. And 4. Damages resulting from such interference. See Hackman versus Dickerson Realtors, Northern District of Illinois, 2008. Janet fails to allege any facts regarding the existing or prospective relationships with which Day allegedly interfered. Per the complaint, the interference claim could be based on any member of the public. There are no specific relationships identified and no facts alleging that Day knew of these potential or existing relationships. Such conclusory allegations are too vague to state a viable claim for tortious interference under Illinois law. And that's, once again, Hackman, where they dismissed a tortious interference claim that alleged defendant's conduct caused unidentified agents to quit Hackman's employ. Moreover, Janet has alleged no facts to support any allegation that members of the public have failed to employ Braun for legal representation as a result of Day's statements. And once again, citing Hackman, where they dismissed a claim for tortious interference based on generic allegations that fall short of establishing the causation required for a claim for tortious interference with an existing business relationship and are too attenuated and too speculative and vague to state a plausible entitlement to relief. And that, of course, is citing to Twombly, our dear old friend. So, would your solicitor by any chance be Jim Carrey, Surrender Monkey? By any chance? Stop committing crimes, asshole. That's good advice. But it's not always the most fun advice, but, you know. The complaint does not state a claim for intentional infliction of emotional distress. Claim, because it couldn't. IIED would just be impossible in this case. Curiously, Propson has asserted a claim for IIED against Day based entirely on Day's alleged defamatory statements about Propson. However, Propson did not assert a defamation claim against Day, and the complaint is devoid of any allegations of defamatory statements made by Day about Propson. Whether this claim was simply a typographical error or an effort by plaintiffs to see what sticks, Propson's IIED claim against Day based on non-existent defamatory statements fails and must be dismissed. So see what sticks. It's throw it against the wall. That's basically what this all seems like, except they're not throwing spaghetti against the wall. They're throwing shit against the wall because this has been terrible. Ooh, it's been bad. So, conclusion, for the foregoing reasons, they respectfully request that this court dismiss the counts asserted by Braun and or Propson against Day for failure to state a claim under Rule 12b-6, dated February 29th and submitted by Brandon J. Witkow, or however you pronounce it, attorney for defendants. And that was an excellent 12b-6 motion. But moving quickly onward, because we still have a whole extra motion to cover, because we've got the Do We Know Them Girlies. And this is defendants Lily Marston and Jessica Vasquez special motion to strike pursuant to OCGA section 9-11-11.1 and California Code of Civil Procedure section 425.16, or alternatively, motion to dismiss pursuant to Federal Rule of Civil Procedure 12b-6. So we have the Georgia anti-SLAPP statute, the California anti-SLAPP statute, and 12b-6. And it's all shoehorned into the same length as Bekah Day's 12b-6 motion. So that's a whole lot to fit into that space. It's a TARDIS. It's bigger on the inside, I guess. But pursuant to the anti-SLAPP statutes, or in the alternative Federal Rule of Civil Procedure 12b-6, and for the reasons stated in the attached memorandum in support, defendants Lily and Jesse, together defendants, respectfully request that this court strike and or dismiss plaintiff Jeanette and Braun IP Law's complaint against them. So moving quickly on to the memorandum in support for Jesse and Lily. Introduction. Defendants Lily Marston and Jessica Vasquez are the third set of social media content creators who have been targeted in this action by plaintiff Jeanette and Jeanette Law, who allegedly is a social media lawyer. Allegedly a social media lawyer. The shade. Allegedly a social media lawyer, for the sole reason that Janet does not like what these two individuals have said about her practice online. As alleged in the complaint, Marston and Vasquez co-host an online podcast called Do We Know Them? Agreed. Damn it, Janet. And yes, that's due process. Due process is basically, do you know what the claims against you are, and do you get a chance to respond? And that's boiled down to its most basic nature, what due process is. But for a plaintiff, it's also, you get to state your case. And if someone, you do a motion to dismiss or a motion to strike, you get a chance to say, no, this is why I'm actually right. So it generally, it does, unless it's an ex parte, which is really, really, really rare that an ex parte motion is allowed. That's just, hey, court, let me do this. The other side doesn't even need to know about it. That's really rare that that's allowed, because it's called an adversary system for a reason. It's your adversaries. You're going against each other. It's you lay out your case, they lay out their case, and the judge gets to decide who is right. Sometimes it's, hey, both of you are a little bit right. Let's go to trial. So, as alleged in the complaint, Marston and Vasquez co-host an online podcast called Do We Know Them?, in which they allegedly promote online controversies, rumors, and celebrity gossip. One such controversy, rumor, and gossip discussed by Marston and Vasquez was Janet's harassing and intimidating litigation tactics on behalf of her social media clients, including plaintiff Lauren Propson, which Marston and Vasquez believed to be unethical. Ironically, in response to Marston and Vasquez voicing their constitutionally protected opinions regarding Janet's unethical tactics, Janet has now utilized that very tactic on them. That might be the title. That might be the next title, Luna Nights. Namely, Janet is attempting to silence their honest but unflattering opinions through this patently defective action, in which Janet asserts defamation and a myriad of other tort claims meant to intimidate Marston and Vasquez. Now, Mr. Ritkow is an excellent attorney, but this is a pet peeve of mine. It's not a myriad of other tort claims. It's myriad other tort claims. Myriad is not a noun. So it's myriad other, not a myriad of other tort claims. But that's besides the point. While it appears that Janet has made a career out of silencing social media content creators, she cannot be permitted to do so in this case. Not only is Janet's claim for defamation legally insufficient, but it is based on a textbook example of protected activity under applicable anti-SLAPP statutes. Statutes which were enacted for the very purpose of preventing this type of lawsuit, brought primarily to chill the valid exercise of the constitutional rights of freedom of speech. All four causes of action asserted by Janet against Marston and Vasquez should be stricken under the applicable anti-SLAPP statutes and or dismissed under 12b-6. And Marston and Vasquez should be awarded their attorney's fees. Case background. Plaintiff Lauren Propson is a licensed mortician and social media personality with allegedly millions of viewers on TikTok. And plaintiff Jeanette Braun, through plaintiff Janet Law, IP Law, blah, 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 is her lawyer. Propson hired Janet to assist with her copyright infringement claims by filing a Digital Millennium Copyright (DMCA) complaint to social media platforms hosting a video created by one of the defendants, KC, the owner and operator of the social media account Caffinated Kitti, hereinafter referred to as KC. I'm just speeding through this part because, you know, we've already read it almost word for word, but on the off chance that there are a few changes to this introduction, I'm rereading it. So, but I am trying to speed through it. Plaintiffs have asserted defamation and other tort claims against Casey and 3 other unrelated individuals, including defendants Marston and Vasquez, based on alleged defamatory statements these individuals purportedly made on social media regarding the dispute between Propson and Casey and Braun and Janet's subsequent representation of Propson. The complaint alleges that Marston and Vasquez are owners and co-hosts of the Do We Know Them podcast, which allegedly is an online weekly video podcast, I think it's twice weekly, in which Marston and Vasquez promote online controversies, rumors, and celebrity gossip. Marston is a citizen and resident of the state of California, and Vasquez is a citizen and resident of the state of Georgia. Janet has alleged a defamation claim and other related tort claims against Marston and Vasquez based on alleged statements they made about her on their podcast and or social media post. Propson has asserted no claims against them. Marston's and Vasquez's alleged defamatory statements. Per the complaint, in November 2023, defendant Vasquez and defendant Marston began posting several videos discussing the dispute between defendants Casey and plaintiffs, in which defendants expressed a strong contempt for plaintiffs, intentionally mispronounced Janet's name, because, yeah, intentionally mispronouncing her name is obvious defamation in Janet land, apparently. Published statements about Janet's clients and her legal practice. The complaint further alleges that, without discussing the full context of any specific post or takedown, defendant Marston stated that Janet's practices were unethical. Poison Song, I know it's late. That's why, yeah, it's good night. Or good morning if you're just waking up to go about your day. Set forth below this allegation is a screenshot from what appears to be episode 97 of Marston's and Vasquez's podcast titled Lauren the Mortician's Lawyer is Way Worse Than We Thought, plus Vlog Squad, Where Are They Now? With a subtitle stating as follows: about a creator, she basically goes to like allegedly unethical lengths to... The screenshot indicates that the episode has, at the time of the screenshot, received 5,500 likes, and that the podcast has, at the time of screenshot, 97.6 thousand subscribers. I think it's 107,000 as of now, when I was watching today's episode. The complaint alleges that in the same episode, Vasquez also states that Janet is unethical and sets forth a screenshot from the same episode with the following subtitle: Is that as unhinged as Janet is, as unethical as Janet is she? The complaint further alleges that Marston continued to make false accusations and accused Janet of unethical behavior on various platforms, without identifying the specific accusations or platforms on which they allegedly were made. Well, she said nasty things on a variety of platforms. What she said or where she said them, that's for you to figure out. Not how it works, Janet. Not how it works. Finally, the complaint alleges that in a since-removed post, Marston made further false accusations and referenced Janet through a past client and accused her of actively committing perjury. Below this allegation is a screenshot of what appears to be a 12/10/23 Twitter post by Marston stating, I gotta say, one of our biggest questions in all of this is, do we think Demps knows that her embarrassing excuse of a lawyer is using her name while actively committing perjury? Someone might want to tell her, because copyright strikes are made under perjury. They're affidavits, they're sworn statements. So if it is a false copyright strike, if I believe you are filing a false copyright strike, I believe you are also committing perjury. But that is, of course, her subjective belief. But we'll let Mr. Whitcow explain that. I'm glad all my tissues are in the other room. But argument: plaintiff's claims should be stricken under applicable anti-SLAPP statutes. The California and Georgia anti-SLAPP statutes apply in this case. In the case of an anti-SLAPP statute raised as a defense to a defamation claim, the choice of law question regarding the anti-SLAPP law is treated separately from whether a statement is defamatory, because the anti-SLAPP question involves whether a statement is privileged, not whether its content is defamatory. So basically, it's the short circuit. It's the auto yeet. It's not even the motion to yeet. It's the auto yeet, using Emily Baker's 12b6 description. That's Osundairo versus Garagos, Northern District of Illinois 2020, citing Underground Solutions Inc. versus Palermo, also Northern District of Illinois 2014. Pursuant to Dépecage, my French is terrible, sorry. The court can apply different states' laws to different elements of the lawsuit. See Underground Solutions. Although the place of alleged injury might be critical in determining the law applicable to the defamation claim, the choice of law for anti-SLAPP protection involves protecting the speaker's exercise of First Amendment rights and could lead to the application of different state law. That's Chicago versus Loyola University Medical Center, Northern District of Illinois, 2011. Namely, in determining which law to apply to defenses raised pursuant to anti-SLAPP statutes, courts have found the place where the allegedly tortious speech took place and the domicile of the speaker central to the choice of law analysis. That's Intercon Solutions versus Basel Action Network, Northern District of Illinois, 2013, affirmed by the Seventh Circuit in 2015. Here, Marston and Vasquez are citizens and residents of the California and Georgia, respectively. I think he meant to say the states of California and Georgia, or the states, California and Georgia. And there is no allegation that the alleged defamatory speech originated anywhere other than California and Georgia. Thus, California and Georgia have a strong interest in protecting Marston's and Vasquez's speech, respectively, and their anti-SLAPP laws apply to Braun's claims, to Janet's claims. See Osundairo and Underground Solutions. And then footnote 1, the Georgia anti-SLAPP statute does not directly conflict with a federal rule of civil procedure and thus is substantive and can apply in federal court. That's Amon versus NBC Universal Media, Southern District of Georgia, 2022. See also Planned Parenthood Federation of America versus Center for Medical Progress, 9th Circuit, 2018, which held that there was no conflict between the anti-SLAPP statute and federal procedural rules when court reviews anti-SLAPP statute based on legal deficiencies under 12b6 standard. So, what, federal rules of civil procedure are substantive law, or the procedural law, sorry. They're procedural law, federal rules of civil procedure. So in federal court, the state rules of civil procedure aren't controlling. It's the federal rules of civil procedure. Imagine that. But in analyzing the substantive law, the law about what you're arguing, not how you're arguing it, state law, state substantive law can be used in federal court, especially if it's a state law claim, as defamation is. Therefore, the state law anti-SLAPP statutes also control, even if it conflicts with the procedural 12b6 motion or 8a standards or whatever. So, yeah. Marston's and Vasquez's statements constitute a protected activity under the Georgia and California anti-SLAPP statutes. As a preliminary matter, the Georgia anti-SLAPP statute set forth in OCGA section 9-11-11.1 and the California ANT-SLAPP. That sounds like a fun game. I'm gonna slap your ants, and I'm talking the diminutive insects, ANT, because that's how it's spelled here. Let's slap some ants, as opposed to Ozzy Osbourne snorting ants. But and the California ANT-SLAPP statute set forth in Code of Civil Procedure section 425. 2.616 are virtually identical, such that Georgia courts look to California case law interpreting the California anti-SLAPP statute for guidance. Remember, we saw that in Caffinated Kitti's anti-SLAPP motion last time, where Georgia didn't have case law on point. They cited California case law because Georgia considers California case law on anti-SLAPP motions, not just persuasive, but like persuasive plus. It's almost, mandatory case law, controlling case law. And that's Wilkes and McHugh, PA versus LTC Consulting, Georgia Supreme Court, 2019. Under both Georgia and California law, the analysis of an anti-SLAPP motion to strike involves 2 steps. See ACLU Inc. versus Zay, Georgia Supreme Court 2021, citing Wilkes and McHugh, Georgia Supreme Court as well. Clarity Co. Consulting LLC versus Gabriel, California Court of Appeals 2022, citing Wilson and Cable News Network, California 5th Circuit, 5th whatever, 5th Division, 5th District, I don't know. It's California. I'm in Utah, but it's from 2019. First, the court must decide whether the party filing the anti-SLAPP motion has made a threshold showing that the challenged claim is one arising from protected activity. That's from Wilkes. If so, the court must then decide whether the plaintiff has established that there is a probability that the plaintiff will prevail on the claim. That's also Wilkes, citing the Georgia anti-SLAPP statute and Oasis West Realty versus Goldman, California, 2011, where the second step in an anti-SLAPP analysis is to consider whether the plaintiff has demonstrated a probability of prevailing on the claim. Surrender Monkey, what's that from? That's not an anteater. It looks like a penis, but smaller. That must be a really big anteater. Wait. No. A protected activity under the Georgia anti-SLAPP statute and the California statute is conduct which could reasonably construed as an act in furtherance of the person's or entity's right of petition or free speech under the Constitution of the United States or the Constitution of the State of Georgia or the California Constitution, in connection with an issue of public interest or concern, a public issue. I mean, sometimes California has a good law that, Georgia's like, yeah, we'll have what they're having. Sometimes they wouldn't agree, but, I think California has a very strong anti-SLAPP law, and if Georgia's policy was, yeah, we'd like a really strong anti-SLAPP law, California was a good state to emulate for that one. So, but yeah, you'd think California and Georgia are awfully, different ends of the spectrum mostly. So it's, I've lost my place. But so protected activities under both the Georgia and California anti-SLAPP statutes include any written or oral statement or writing or petition made in connection with an issue under consideration or review by a legislative, executive, or judicial body or any other official proceeding authorized by law. Any written or oral statement or writing or petition made in a place open to the public or a public forum in connection with an issue of public interest or concern, and whether or not there's a rogue attorney filing false copyright strikes, is an interest of public concern, or it's a subject of public interest or concern, especially on YouTube and TikTok. That's where it's most concerning. And any other conduct in furtherance of the exercise of the constitutional right of petition or free speech in connection with a public issue or an issue of public concern. See Barnwell versus Trivedi, Georgia Court of Appeals, 2022, citing the Georgia anti-SLAPP and California anti-SLAPP statutes. And then footnote 2, the California statute varies slightly in text from the Georgia statute, defining an act in furtherance of a person's right of petition or free speech under the United States or California Constitution in connection with a public issue to include any written or oral statement or writing made in a place open to the public or a public forum in connection with an issue of public interest and any other conduct in furtherance of the exercise of the constitutional right of petition or the constitutional right of free speech in connection with a public issue or an issue of public interest. So, slight difference, doesn't really matter. There. So I don't know that it's a lesser dragon. It's just a different dragon. You know, like the dragon's brother, or, you know, good-looking college roommate, or whatever. The statute is intended to protect persons exercising their constitutional rights of petition and freedom of speech. To accomplish this goal, the statute is to be construed broadly. That's from Barnwell in Georgia and Greater LA Agency on Deafness, Inc. versus Cable News Network, Ninth Circuit, for the California statute. And the California statute states that it shall be construed broadly, and the California Supreme Court has interpreted the anti-SLAPP statute broadly, cautioning that a narrow construction would serve Californians poorly. So not only does the California Supreme Court state that it's to be construed broadly, but it's in the statute itself. Whereas in Illinois, it was meant to be construed broadly, and it was initially construed broadly, but then the Illinois Supreme Court reversed itself and said, yeah, this is really narrow, actually, so fuck you. But there can be no question that Janet's claims here are based on statements made by both individuals in a public forum in connection with a public issue or an issue of public concern, or a public issue. See the both anti-SLAPP statutes. The complaint alleges that the statements were published on the internet in connection with a podcast that has at least 97.6 thousand subscribers, and the video itself received at least 5,500 likes. Why not tell the views, Janet? That sounds like it would be more important than the likes. You know, it's how many people saw it, not how many people agreed with it. But, you know, you do you. The complaint also alleges that Marston made an additional alleged defamatory statement on Twitter. Social media and online platforms are considered public forums under both Georgia and California anti-SLAPP statutes. See Equity Prime Mortgage versus Green for Congress for the Georgia statements, where statements made on social media fell within scope of Georgia's anti-SLAPP statute. And Pre-Hired LLC versus Provins, Eastern District of California, for the California statute, where statements posted on internet sites are posted in a public forum within the meaning of the statute. To determine whether an issue is an issue of public concern under the Georgia anti-SLAPP statute, courts consider whether the subject of the speech or activity was a person or entity in the public eye or could affect large numbers of people beyond the direct participants, and whether the activity occurred in the context of an ongoing controversy, dispute, or discussion, or affected a community in a manner similar to that of a governmental entity. That's Ammon versus NBC Universal Media, Southern District of Georgia, 2022, citing Lane Durham versus Smith, Georgia Court of Appeals, 2021. Courts also broadly construe the phrase issue of public interest when applying the California anti-SLAPP statute. That's citing Pre-Hired, where an issue of public interest is any issue in which the public is interested. In other words, the issue need not be significant to be protected. It is enough that it is one in which the public takes an interest. See Cross versus Cooper, California Court of Appeals, 2011. And Film on TV Inc. versus Double Verify, California 5th District, I think, 2019, where courts look to whether the subject of the speech or activity was a person or entity in the public eye or could affect large numbers of people beyond the direct participants. Marston's and Vasquez's statements on their podcast, as well as Marston's statement on Twitter, constitute a matter of public interest or concern and thus qualify as protected activities under both the Georgia and California anti-SLAPP statutes. This is not a matter that affects only Marston and Vasquez and Jeanette. Rather, they were communicating to their over 97,600 subscribers about Jeanette's litigation tactics on behalf of her social media clients and their impressions of Jeanette based on her conduct, namely their belief that Janet's practices are unethical. When the alleged defamatory statements are viewed in the context in which they were made in the video referenced in the complaint, i.e. episode 97 of the podcast, as opposed to merely the screenshots included in the complaint, it is apparent that Marston and Vasquez are alerting their viewers to their belief that Jeanette is utilizing unethical litigation tactics and trying to intimidate social media content creators who post content that Janet's clients find unflattering. Indeed, with respect to the screenshot in paragraph 89 of the complaint, the allegedly defamatory statements made by Marston and or Vasquez in context are as follows. And that's the common thread. Jeanette takes down things that are either embarrassing to a creator or negative about a creator. She basically goes to like allegedly unethical lengths to silence people's critics or bullies, as she says, but like, come on. And footnote 3, the complete video in which the alleged defamatory statements were made can be viewed using the link. Lauren the Mortician's lawyer is way worse than we thought, plus Vlog Squad, where are they now? Episode 97. And of course, this is the hyperlink. I'm not going to click on it. As this court held in considering transcript of television shows and a podcast on which defendants made alleged defamatory statements in ruling on sufficiency of the complaint, while courts normally do not consider such extrinsic evidence without converting a motion to dismiss into one for summary judgment, where a document is referenced in the complaint and central to plaintiff's claims, the court may consider it in ruling on the motion to dismiss. That's citing Osundairo. This standard is met where a plaintiff explicitly refers to a media appearance in their complaint and the very statements at issue were made by defendants during these media appearances. Because Jeanette explicitly refers to episode 97 of the podcast in the complaint, and the very statements at issue were allegedly made by Marston and Vasquez in episode 97, the court should consider the video itself, rather than screenshots of the video when determining the sufficiency of the complaint. Further, given that the video is over 1 hour and 24 minutes in length, defendants feel a lengthy written transcript of the entire episode would not be useful to the court. However, defendants are happy to submit a written transcript of the entire episode upon the court's request, should the court deem it useful. Where have we seen this before? Oh, yeah, that's right. Delete Laws has probably incorporated the body cam by reference into his amended complaint against the LVMPD. Therefore, the court should be able to consider it in the 12B6 motion. But they have also, you know, it's or in the alternative, motion for summary judgment. In that case, here it says, you know, while courts don't normally consider outside evidence, meaning not in the complaint itself, in ruling on the sufficiency of a complaint or without converting it to a motion for summary judgment. So yeah, basically what they're saying here is, hey, look, by including the screenshots and one line of transcript in the complaint, Janet has incorporated the entire episode, the entire video, because the court should look at the complete statement, not one snippet of the statement taken out of context to make its ruling. So yeah, I agree. Because frankly, even just what we've seen here, adding 2 extra lines adds so much extra context that it can't possibly be defamation. It shows it's their opinion. Because let's look at it again. Nah. Likewise, with respect to the screenshot at paragraph 91 of the complaint, the allegedly defamatory statements made by Marston and or Vasquez in context are as follows. Okay, so that's the common thread. We believe is that Bunny XO, longtime client of Janet's, has been referring to this girl, or has been referring this girl, Janet, to everybody, and all of a sudden, Janet is way too many people's lawyer, as I said. The crazy part is that as unhinged as Janet is, as unethical as Janet is, she is finding some success in her practices, like whether short-term or not, but like she's kind of low-key slaying, but in the worst way. So, and that was footnote 4. As alleged in the complaint, Marston and Vasquez referred to Braun as Janet. So they go on to discuss how it seems like Janet was successfully silencing content creators and no one was coming forward until now. And it's just like there is no shortage of people Janet has harassed with legalese and a bunch of gibberish. I like that. Legalese and a bunch of gibberish. Most people don't understand, and they'll just be like, I'm going to jail. Marston's Twitter post alleged in paragraph 93 of the complaint similarly relates to a statement regarding unethical tactics engaged in by Braun, Janet, on behalf of one of her social media clients referred to as Demps. I mean, to be fair, the allegations where, you know, I can't remember if it was Lily or Jesse, but where, she's getting clients, she's low-key slaying, but in the worst way. Technically, that was before, so we don't know that she's gaining or losing clients now. But some of the more unethical content creators might see this and they'll be like, holy shit, I can hire an unethical lawyer and she'll do this for me? Wow. Sign me up. So, as terrible as a lot of content creators are, being an unethical attorney might be a selling point. It's like on Better Call Saul. Why get yourself a criminal attorney when you can get yourself a criminal attorney? Under both Georgia and California law, statements that Janet is engaging in unethical or harassing conduct is unquestionably a matter of public concern affecting a large group of individuals, i.e., social media content creators who might be targeted by Janet or who might be considering using Janet as a lawyer. Marston's and Vasquez's warnings to content creators about Janet's conduct in episode 97 is a protected activity under the anti-SLAPP statutes, regardless of whether the warning was sincere, accurate, or truthful. See Piping Rock Partners, Inc. versus David Lerner Associates, Northern District of California, 2013, which found that online blog post warning consumers not to do business with plaintiffs because of their allegedly faulty business practices concerns an issue of public interest, and it makes no difference for purposes of the public interest requirement that the warning was not sincere, accurate, or truthful. See also Shaker versus Matteo, California Appeals Court, 2012, which concluded that online statements regarding plaintiff's character and business practices were of public interest because they were intended to serve as a warning to consumers about his trustworthiness. Then see the ACLU case in Georgia, which held that statement on a blog post that public defender had charged an indigent defendant was protected under the Georgia anti-SLAPP statute. And footnote 5, Marston's and Vasquez's statements also constitute a protected activity under both Georgia and California anti-SLAPP statutes because they were made in connection with an issue under consideration or review by a legislative, executive, or judicial body or any other official proceeding authorized by law. And statement made in connection with an issue under consideration by any official proceeding is a protected activity. The filing of a complaint or copyright strike under the DMCA constitutes an official proceeding, as it is expressly authorized by law. Thus, it constitutes an official proceeding authorized by law. And Marston's and Vasquez's alleged statements made in connection with DMCA strikes filed by Janet are protected. Next up, there is no probability that Janet can prevail on her claims. Once a defendant has established that the claims asserted against it arise out of protected activity, as Marston and Vasquez have done here, the burden then shifts to the plaintiff to demonstrate that there is a probability that the plaintiff will prevail on his or her claims. So basically, the initial burden for an anti-SLAPP motion is the party bringing the motion, meaning the defendants. But if they successfully prove, if they successfully allege the first bit, the burden shifts to the plaintiff to prove why it should not be dismissed immediately. So that's what this section is. And that burden is to show that there's a probability that the plaintiff will prevail on his or her claims. And like I said in last week with Kitties, don't quote me, but to me, the probability sounds like it's higher than a preponderance standard. It might be like clear and convincing, but I could be wrong. I don't practice anti-SLAPP, so. But when I see probability, to me, that sounds higher than preponderance, which is anything above 50%. But I could be wrong. In federal district court, an anti-SLAPP motion may be premised on legal deficiencies inherent in the plaintiff's claim, analogous to a motion to dismiss under Federal Rule of Civil Procedure 12b-6. And if a defendant makes a special motion to strike based on alleged deficiencies in the plaintiff's complaint, the motion must be treated in the same manner as a motion under Rule 12b-6, except that the attorney's fee provision of the anti-SLAPP statute applies. So it's even better than a 12b-6 where you're not guaranteed attorney's fees. And that's citing the Planned Parenthood case. See also on Osundairo, which is the Illinois case, which basically they all say the same thing, that attorney's fees apply. Though a complaint need not contain detailed factual allegations, a formulaic recitation of the elements of a cause of action will not do. That's Twombly. Rather, the complaint must contain enough facts to state a claim to relief that is plausible on its face. Here, Jeanette has failed to state facts sufficient to constitute any cause of action against Marston and Vasquez. Thus, each of the claims should be stricken and attorney's fees should be awarded to Marston and Vasquez under the Georgia and California anti-SLAPP statutes. Next up, Braun, Jeanette, cannot prevail on her defamation claim. To state a claim for defamation under Illinois law, and footnote 6, I'm guessing it's going to say the same thing as the footnote over on Bekah Days did. It's going to say for defamation, Illinois law applies, even though the Georgia and California anti-SLAPP laws apply. So I'm not going to scroll down to footnote 6 just yet. But to state a claim for defamation under Illinois law, a plaintiff must plead facts showing 1, the defendant made a false statement concerning the plaintiff, 2, there was an unprivileged publication of the defamatory statement to a third party by the defendant, and 3, publication of the defamatory statement damaged the plaintiff. That's Brennan versus Kadner, Illinois Court of Appeals, 2004. Here, count 4 of the complaint alleges that Marston and Vasquez defamed Jeanette by publicly stating that Jeanette is unethical and commits perjury, and using their platform to attack Janet's character and reputation. And footnote 7, a general allegation that Marston and Vasquez defamed Jeanette by using their platform to attack Janet's character and reputation does not state a claim for defamation under Illinois law because it does not identify any particular statement that forms the basis for this allegation. And that's quoting Osundairo, which held that plaintiffs do not identify any particular statement that forms the basis for this allegation. This imprecision leaves defendants and this court guessing as to which statements are at issue. And if you have to guess what the defamation is, you haven't stated a claim for defamation. And I was right about footnote 6. It's for defamation, the law of the state where the injury occurred governs. So I was right there. The allegation that Marston and Vasquez defamed Jeanette by stating that Jeanette is unethical cannot state a claim for defamation under Illinois law, as such a statement constitutes a non-actionable opinion protected under the First Amendment. A statement is constitutionally protected opinion if it cannot reasonably be interpreted as stating actual facts about the plaintiff when viewed from the perspective of an ordinary reader. That's Doctors Data Inc. versus Barrett, Northern District of Illinois, 2016. To determine whether a statement is factual in nature, Illinois courts consider whether the statement has a precise and readily understood meaning, whether the statement is verifiable, and whether the statement's literary or social context signals that it has factual content. If it is clear that the speaker is expressing a subjective view or interpretation, such as when the speaker discloses the facts forming the basis for the statement is not actionable as defamation. Here, it is clear that Marston and Vasquez are expressing their subjective opinion that Braun is using harassing litigation tactics to intimidate social media content creators who post unflattering statements about her clients, tactics that Marston and Vasquez deem to be unethical. Moreover, it is impossible to verify whether Janet's conduct is unethical because the term has no precise and readily understood meaning. See Solaya Tech versus Specialty Publications Inc., Illinois, 2006, which, once again, the phrase deeply greedy people has no precise meaning and it is not verifiable. It may have been judgmental, but it was not factual. This statement is not actionable. Once again, the hypothetical statement that Janet uses her unethical lawyering tactics because she is a deeply unethical federal civil attorney would be non-actionable if I said it as a pseudo-factual statement and not as a hypothetical as I did here, even if I may agree with it. Indeed, in Tamburo versus Dworkin, Northern District of Illinois, 2013, the court held that statements that a plaintiff's actions were unethical and deceitful are plainly subjective, not objectively verifiable, and not actionable. That's, once again, citing Dworkin. See also Black versus Wrigley, holding that defendants' alleged statements that lawyer and law professor acted unethically during litigation and is unfit to be a law professor are also non-actionable expressions of opinion. Also Hopewell versus Vitullo, which held that the term incompetent is a non-actionable opinion because there are numerous reasons why one might conclude that another is incompetent. One person's idea of when one reaches the threshold of incompetence will vary from the next person's. Sullivan versus Conway. It would be unmanageable to ask a court in order to determine the validity of the defendant's defense of truth to determine whether, in fact, Sullivan is a poor lawyer. Moreover, the complaint admits that the unethical statement was made without discussing the full context of any specific post or takedown. Without factual context, a statement cannot be actionable. That's citing Pearsall versus Sports Vision of Chicago, Illinois Court of Appeals, 1992. Equally defective is Janet's allegation that Marston defamed Janet by stating in a Twitter post that she commits perjury. The Twitter post does not identify any particular statement made by Janet that Marston contends constitutes perjury. Essentially, this statement is nothing more than Marston calling Janet a liar without any factual context. Illinois law is clear that a general statement that someone is a liar, not being put in context of specific facts, is merely opinion. That's citing Pearsall, and see also Chiavarelli versus CBS, Illinois Court of Appeals, 2002, which held that a statement that plaintiff was cheating the city in the absence of any factual context was a non-actionable opinion as it was too broad, conclusory, and subjective to be objectively verifiable. And once again, I'm pretty sure I know the context of her statement, but Janet hasn't provided any context. So saying, yeah, Janet commits perjury is about the same as saying, yeah, this person cheats the city. How can you not see that they cheat the city? So, yeah. For this statement to be actionable, Marston's Twitter post would have had to provide some factual context as to why or how Braun, Janet, had committed perjury, and it did not. See Black, which held that statements that as a statement that plaintiff's testimony lacked credibility was opinion because defendant did not specify the subject of the testimony to which she refers or explain what made the testimony less credible. Thus, it does not contain an objectively verifiable assertion. Moreover, under Illinois law, social contexts are a major determinant of whether an ordinary reader would view an alleged defamatory statement as constituting fact or opinion. That's Brennan. Thus, where potentially defamatory statements are published in a setting in which the audience may anticipate efforts by the parties to persuade others to their positions by use of epithets, fiery rhetoric, or hyperbole, language which generally might be considered as statements of fact, may well assume the character of statement of opinion. That's still Brennan, where a statement was deemed opinion because it was made in the literary context of a regularly featured column by a journalist who regularly expressed his personal opinions on a wide range of public and social issues. See also Freyden, which held that statements posted on Facebook, Yelp, and Google pages, which invite unfiltered comments, were opinion and not fact because readers of online reviews are skeptical about what they read, both positive and negative. So going back to my example from Yelp, my statement that the fish and chips was like a fish Twinkie, that was my opinion. And, you shouldn't take it as fact that, that fish Twinkie was sold by Hostess at that brew pub. But never try a fish Twinkie. It's not worth it. Ooh, it's not worth it. Don't, in the world of business ideas, selling fish Twinkies is a bad one. Just saying. Here, the complaint alleges that Marston and Vasquez made the alleged defamatory statements on an online podcast that promotes online controversies, rumors, and celebrity gossip. Certainly, their viewers would understand that their general statements regarding Janet's ethics or litigation tactics in the context of an online controversy to be opinions. The fact that these statements were made on the internet and social media posts further underscore that they constitute an opinion. Footnote 8. Courts have emphasized the generally informal and unedited nature of statements made on the internet. The court said, the culture of internet communications as distinct from that of print media, such as newspapers and magazines, has been characterized as encouraging a freewheeling, anything-goes writing style. Social media platforms are equally, if not more, informal and freewheeling, and as such, convey a strong signal to a reasonable reader that a statement is opinion. It's almost like we just read this less than an hour ago. Not only are Marston's and Vasquez's statements about Janet non-actionable opinions, but they are also subject to a qualified privilege under Illinois law. Such a privilege may exist where the situation involves an interest of the person who publishes the defamatory statement or an interest of the person to whom the matter is published. That's Tamburo once again. Courts also recognize as privileged communications involving a recognized public interest. Whether a qualified privilege exists is a question of law for the court. Marston's and Vasquez's statements are privileged because they relate to their own and their viewers' interest in protecting their freedom of speech as social media content creators and not being subject to intimidating litigation tactics by Janet on behalf of her clients, as well as the public interest in protective free speech on social media. That's Tamburo, and see also Haywood versus Lucent, and Ludlow versus Northwestern. And once qualified immunity has been identified, a plaintiff may overcome this challenge at the pleading stage by alleging the statement was made with actual malice, either knowledge of its falsity or in reckless disregard of the truth, but must do so with more than conclusory statements. Here, the complaint fails to satisfy this burden. Because the complaint fails to state a claim for defamation, Janet cannot satisfy her burden under the Georgia and California anti-SLAPP statutes of demonstrating a probability of prevailing on the claim. Next, Janet cannot prevail on her false light and trade libel claims. Janet cannot demonstrate a probability of prevailing on her false light claim, count 8, or trade libel claims because they are based on the same failed allegations as Janet's defamation claim. Because Janet cannot state a claim for defamation, see above, these claims must fail as well. See Madison versus Frazier, 7th Circuit 2008, which says, when an unsuccessful defamation per se claim is the basis of a plaintiff's false light claim, his false light invasion of privacy claim fails as well. Next, Janet cannot prevail on her tortious interference claim. Basically, same reason as the previous two we read, but we'll speed through it. A claim for tortious interference requires that plaintiffs show 1, the reasonable expectation of entering into a valid business relationship, 2, defendant's knowledge of that expectancy, 3, purposeful interference by the defendants preventing that expectancy from being fulfilled, and 4, damages resulting from such interference. See Hackman versus Dickerson Realtors. Janet fails to allege any specific facts regarding the existence or prospective relationships with which Marston and Vasquez allegedly interfered. Rather, the complaint alleges only conclusory allegations that they have caused the public and content creators not to employ Janet. Janet identifies no specific relationships and alleges no facts that Marston or Vasquez knew of these relationships. Such conclusory allegations are too vague to state a viable claim for tortious interference. And that's quoting Hackman again, which dismissed tortious interference claim that alleged defendant's conduct caused unidentified agents to quit Hackman's employ. Moreover, Janet has alleged no facts to support any allegation that members of the public have failed to employ Janet for legal representation as a result of Marston's or Vasquez's statements. Instead, the complaint relies on a conclusory assertion that their statements have caused or are likely to continue to cause people not to hire Janet. I think Janet's actions are what will cause people not to hire Janet. Am I right? That simply is not enough to state a claim for tortious interference. And that's citing the realtor case above, which dismissed a claim based on generic allegations that fall short of establishing the causation required for a claim for tortious interference with an existing business relationship and are too attenuated and too speculative and vague to state a plausible entitlement to relief. Because the second prong of the anti-SLAPP statutes has been satisfied, Marston and Vasquez respectfully request that the court strike the claims and award them their attorney's fees. Alternatively, Janet's claims should be dismissed under 12b6. As explained above, Janet is not likely to prevail on any of the 4 causes of actions asserted against Marston and Vasquez because they are legally insufficient, i.e., they fail to state a claim under 12b6. If the court determines that Marston's and Vasquez's conduct is not protected activity under applicable anti-SLAPP statutes, they respectfully request that the court dismiss the claims under Rule 12b6. And we've discussed above why it doesn't pass 12b6 muster. And yes, Lunanites, actions absolutely can speak louder than words. And Janet's actions scream over the top of any words that Lily and Jesse have spoken in this case. But Janet is too blind to see that. Conclusion. For the foregoing reasons, Marston and Vasquez respectfully request that this court strike the counts of the complaint against the 2 of them and award them the attorney's fees they have incurred in connection with this motion under the Georgia anti-SLAPP statute and the California anti-SLAPP statute, or alternatively dismiss the counts for failure to state a claim under Rule 12b6. Respectfully submitted, Brandon J. Whitcow. And so this could actually lead to an interesting outcome. Since Bekah Day living in Missouri, why would anyone want to live in Missouri? But since Bekah Day lives in Missouri, and Missouri does not have an anti-SLAPP statute, she hasn't filed an anti-SLAPP statute. Now, all 4 of the girlies have shared a GoFundMe, which, go check that out if you want, for attorney's fees. And they've said, yeah, well, it's, it's a common pool. It's to pay the attorneys. And if, let's say 3 of us are dismissed and 1 isn't, we keep it going for the other person, and, yada, yada. What could be happening here is 3 of them get their attorney's fees covered. And so the GoFundMe, even though it went for, I'm assuming, a retainer for all 4 of them, it gets wholly applied to Bekah's portion of the attorney's fees. And that could be interesting. Not that, not that we're actually privy to it any more than, potential participation in the GoFundMe, would indicate. But either way, that's an interesting thought. But either way, that is the end of it. And I think you should all be impressed that this was, for all intents and purposes, the same number of pages as the Caffinated Kitti motion, but we got through it in 3/4 of the time. Of course, part of that is speeding through the second half of it that was largely duplicative of the first half. But either way, you should be impressed. I mean, you should always be impressed by me, but, you should doubly so for that. But with that, I'm glad it only took 3 hours instead of 4, because I am definitely feeling that my voice is shot. It's a little past midnight here, so I think it's time to go. So either way, thanks for joining me. Thank you to Leonard, Debbie. I will hopefully see you all very soon for the next one. I'm not quite sure what I'll pull out of the hat for the next one because, you know, there are a couple cases I'm behind on, as I keep saying. But either way, thanks for joining me. Do all the YouTubey things, like, share, subscribe, bribe your friends and family to do the same. Remember, I didn't mention it at the beginning. This was streamed on Twitch as well. So if you are a Twitcher person, go follow me there because, you know, help me build that up. If for some reason you did watch this on Twitch, please subscribe to my YouTube. And now that Europe has woken up, Kane, I'm, well, not going to bed yet, but I'm getting off. But I think you might have been the one that left the comment on the previous video about tortious interference with a contract. If you did, I answered it about an hour and a half ago, so go back and watch it. So yeah, but either way, thanks for joining me, and bye-bye.